5 seconds to go. Start. The crucial issue emphasized before us was that the terms of the insurance policies are to be strictly construed and undisputedly accepted. On behalf of the Chief Electoral Officer, a slightly divergent case, as apparent from the impugned order, was sought to be made before us, countering any admission of liability to pay the insurance amount in the supplementary counter affidavit. It was submitted that the supplementary counter affidavit in the writ petition only stated that it was a fit case to be recommended for payment in view of the judgment in Kamalavati Devi versus the State of Bihar and others. The letter dated 10th February 2000 issued by the Chief Electoral Officer had clarified that the primary burden to file the claim for insurance amount before the appellant insurance company was on the wife of the deceased. It is mentioned that there was also an inordinate delay in the representation made by respondent number 2 wife and that it was made for the first time on 21st November 2008, almost 7.5 years after the death of the police official. It had been clarified that the death of the police official was caused by a heat stroke and his death was not covered under the MOU and thus delay in raising claim was not exclusively driven by the Chief Electoral Officer. The role of the Chief Electoral Officer was limited to forwarding the recommendation, which it duly did. The husband of respondent number 2 died during the currency of the insurance policy, and thus it was pleaded that the appellant insurance company, as the insurer, was under an obligation to honor the promise of paying the insured amount in case of death of an employee while on election duty during the sustenance of the insurance policy. On consideration of the rival contentions, there are two aspects which needs to be flagged. Firstly, the consequences of delay in claiming the amount from the appellant insurance company. Secondly, whether at all the insurance policy covered the scenario of the death of the constable. On the first aspect, the admitted position is that respondent number 2 never raised a claim even on the Chief Electoral Officer seeking an entitlement of the claim till the letter dated 21st November 2008 after 7.5 years. Thus, by any standards, this claim was beyond any reasonable time period. Let us say that even if the wife had not claimed and the appellant insurance company were of the view that the case was covered by the policy, then it was the bounden duty of respondent number 1 to have lodged that claim. It cannot countenance the submission that while on one hand the claim made by the wife was initially rejected, subsequently it is re-examined, almost as if making it a precondition to fasten the liability on the appellant insurance company. The conditions of the MOU required the claim to be made immediately on the occurrence. The relevant clause is as under. The claim will be intimated to the National Insurance Company Limited immediately on its occurrence at its regional office. On receipt of the intimation, the local office at the place of occurrence shall be liaising with the government agencies in getting the desired papers completed in all respect. It appears to us that in their own wisdom, respondent number 1 never thought that it was a case for which claim should be lodged with the appellant insurance company. Thus, whether the claim was admissible under the insurance policy or not, the conduct of respondent number 1 would not entitle them to fasten the liability on the appellant and would have to be borne by them if they are of the view that such an amount ought to have been made. It would be negligence of respondent number 1 in lodging the claim. If it was not admissible, then there is no reason to forward the claim to the appellant. Respondent number 1 has been actually playing ducks and dogs with the issue of reasons best known to them. The aforesaid could actually end the discussion before us, but since the issue of the liability of respondent number 1 has in turn raised the question about the incident being covered by the insurance policy, we consider it appropriate to even answer that question. We would first like to elucidate the principles on which a claim under any insurance policy is examined. It is tried to say that the terms of the insurance policy are to be strictly construed. The insurance contracts are in the nature of special class of contracts having distinctive features such as utmost good faith, insurable interest, indemnity, subrogation, contribution and proximate cause, which are common to all types of insurances. Each class of insurance also has individual features of its own. The law governing insurance contracts is thus to be studied in three parts, namely general characteristics of insurance contracts as contracts, special characteristics of insurance contracts as contracts of insurance, and individual characteristics of each class of insurance. Stop.